Hello, this is Harper, and welcome to your Texas Divorce and Child Custody class. This is your overview class. It is not the class on the specific steps, so this will give you a broad picture of the roadmap of your Texas divorce. So let's get right into it and what you can expect from this class. Now, a Texas divorce is a civil case. It's usually in district court or a county court at law with family jurisdiction. And if kids are involved, custody and support ride inside the divorce through something called an SAPCR, which sounds like a printer brand, but it's really the suit affecting the parent child relationship. What a Texas divorce includes is a full combo platter. You've got marriage dissolution, you have property and debt division, and Texas is a community property state, but the standard is just and right, which is lawyer speak for it depends. If there are children, you're also addressing conservatorship and possession and access plus support. You may also deal with temporary orders, discovery, and the grand finale, settlement, or trial. Here's the roadmap. Think of this as your GPS, except it actually tells you where the speed traps are. Step one is jurisdiction and venue. You want to confirm that you have this, confirm you know where your ex is staying now, your soon to be ex, rather. Your relief list, what you're looking for, your draft of your petition, filing it. And once you file the petition, something called a standing order will come into place. It's an order that affects everybody that files in the family court, regardless of facts. It just applies to everybody. You'll get a copy of that standing order and make sure you follow it. Typically, it covers things like traveling outside the state with children and things of that nature. After that, you're going to serve your spouse, and this is very important. We'll talk about that later. They will have a deadline to answer once you serve them. After that, temporary orders go into place. SAPCR basics will go into effect. Child support will be determined. There will be a mediation at some point in here, most of the time, and after which time you'll determine if you settle or if you're going to trial. So, step one, you confirm jurisdiction and venue. So, you have to be a resident of Texas, you or your spouse, for at least 6 months before you file. And the county, and that's just for the state. And then you have to figure out if you're filing in the right county. You must have resided in that county for at least 90 days. And make sure you have, your estranged spouse's proper address. You know where to find them. You know how to get them served properly. Because these little steps, they sound little or small or technical, but these are the things that are the missteps that can get your entire case thrown out. And it's a big waste of time and money. So you file in the district or county court at law with family jurisdiction. So the clerk will tell you if it's not proper jurisdiction, but you file in the family jurisdiction of the county where you or your ex resides. And most of the time, it's where your ex is residing. Your relief list. Before you draft anything, write down what you want the final decree to do. This mentally helps you put you on a good path to staying focused on your goals and objectives. Your property and debt division, write that down. Your spousal maintenance, if you're looking for that, if you want to change your name back, the children, their schedules, any temporary orders that you need now, retirement, things of that nature. And also start gathering your paperwork while you're doing this. You're going to need at least a year's worth of bank statements, sometimes up to three. Um, Pay stubs, tax returns, things of that nature. Start pulling that together so when the deadlines come, you are not overwhelmed. Then you're going to draft your petition. You're going to put where you live, where your spouse lives, the date you were married, the year, the place, the grounds for the divorce. These, can vary a little bit from state to state. Most people plead no fault, even if they feel like their other spouse is at fault, because it's not necessary. There does not have to be a fault identified in order to get a divorce. SAPCR requests if children are involved, property and debt division, maintenance request, and a prayer listing at the end, which is just listing the relief that you want from the court. For example, if you want the house, if you want child custody, things of that nature. And we'll definitely go into detail about that as we move on. At that point, once you've drafted it, you have the list of what you're looking for. That's you keep that. You don't give that to the court. You have your personal list of your goals and objectives. You're gathering your paperwork and documents, and you've drafted the petition. You take your petition, not with your bank statements or anything, not yet. Those don't come into play yet, but you just take the petition that you've drafted down to the courthouse and you file it with a clerk. There will be a filing fee unless you qualify for a waiver. And at that point, they will assign a case number and they will stamp it. And you need to worry about getting the case served. Now, as I mentioned earlier, once you get the case filed, the standing order comes into place. And these, like I said, apply to every single person that files in that county. And they typically include provisions like do not harass the other spouse, do not transfer money or assets or spend a bunch of money, do not take the children out of state, things of that nature, not making any major disruptions to the status quo while the action is pending. Read that and make sure you follow it, because if you do not follow it or if your spouse does not follow it, you can move for contempt on that. So you'll have the standing order, and then you'll have specific orders, especially for your case, but the standing order applies to everybody. Service of process. Now, you cannot serve the paperwork yourself. You cannot mail it yourself. You cannot hand it to them yourself. You cannot have a friend do it. It has to follow very specific laws that we will get into later. And if it doesn't follow those laws and it's done improperly, it doesn't matter that they actually knew about the divorce. If they did not get it properly in compliance with the law, they can have the whole thing thrown out. So you want to make sure that this is done right and in compliance with Texas law. Your spouse can waive service if they're being cooperative and sign in front of a notary and sign a paper saying that they waive service. But we are, I guess, guiding you as if everything is going to be contested in a major fight. So that's what we're planning on. But that is an option. But you cannot just hand it to them yourself and tell the court, well, they knew about it. I gave it to them, or I told them during our last fight, or whatever. It has to be done in compliance with the law or waived in compliance with the law. The answer is due by 10 a.m. Their answer to your petition that you filed is due at 10 a.m. on the Monday, the next after 20 days from service. So after 20 days, that following Monday, their answer is due. Risking this can put you at risk for missing this can put you at risk for default judgment. Now, because it's a family case, judges are not quick to throw things into default. But if you're the person getting served, be on top of it. Monitor that deadline. Start out on a good foot, and letting the court know that you take it seriously. Because it is family law, they're not going to strictly put you in default. But however, you don't want to play with that, and don't. So watch out for deadlines, meet those deadlines, and let the court know that you're taking it seriously. After service and an answer and a counterclaim, at that point, temporary orders and the necessity of temporary orders can come into effect, whether or not you want temporary possession of the house, temporary child custody, things of that nature. So you will file motions, which a motion's just asking the court to do something. So it's you're asking the court for temporary possession of the marital home or temporary child custody and child support. So those motions get filed to establish temporary relief while the final divorce is pending and you go through discovery. Texas uses somewhat different terms for child custody. They call it conservatorship, custody who has legal rights and responsibilities, and then possession and access is who is visiting and exercising parenting time. So this is just the typical custody terms that we're normally used to hearing is custody, visitation, custodial parent. Texas likes to do things differently because it's Texas. So we will use Texas terms while we're dealing with Texas, and just get familiar with that and don't let it throw you off. Parenting plans in Texas, we will go into that as well in a different course, or in a lesson within this course, rather. They'll establish a weekly schedule, holidays and school breaks, things of that nature, who has certain decision makings over certain issues, things like that. And a lot of times have to get extremely detailed to keep from problems arising later. Child support will be determined during this action, and we are not math teachers. we are not math teachers here. I cannot stress that enough. But we will direct you to a proper online calculator that will give you the ability to do the computations and the deviations yourself accurately. So we will direct you to that in the child support class. But this slide just kind of gives you an overview of what to expect um, when you're looking at paying child support. And 5+ children, my goodness, over 40% of your income. Wow. Okay. Now, during the temporary orders in that phase, at some point, and you're exchanging discovery, you're exchanging documents, so the court can have the complete picture of your finances and debts and the children's best interest. At some point, mediation will come into play. And if you can reach a settlement during mediation, that is the best case scenario. If you cannot reach a settlement and come to an agreement, then the case goes to trial and a third party stranger determines the rest of your life. And that's scary, guys. It's really scary. So try to work things out if you can. If you can't, then you can't. You go to trial and we'll get into trials. But you don't want a stranger determining your life if you don't have to. So if you can settle, that is always the best route financially, emotionally, everything, logistically. Texas has a 60-day rule after filing before a divorce can be granted. I guess a cooling off period to make sure that you didn't just rush into it. After the final decree is implemented, you have to prepare a retirement statement, which is called a quadro. Update your beneficiaries on life insurance, transfer titles, set up child support withholding, things of that nature. Just tying up the loose ends once the final decree is implemented, making sure that you follow it, transfer the property, things of that nature. Texas is a community property state, which means just and right division standard. That's legal jargon for the court. Doesn't necessarily divide things equally. They divide things based on what they think is fair. So that's not always 50-50. Sometimes somebody will get a little bit more or a little bit less, depending on what's fair and the circumstances involved. Common traps when you're representing yourself is missing the answer deadline, not serving properly. I cannot stress this enough. That's even more important than the answer deadline. You have to serve your spouse properly. You absolutely have to. Ignoring the standing orders. That's important. You can't just take the kids out of state. You can't just go into the bank account and spend all the money, or you'll get into a lot of trouble that you have to answer for. Forgetting to request temporary orders and spousal maintenance, that can cause a lot of problems as well. Another one is assuming verbal agreements are enforceable. Now, it can be used as evidence for sure, but they aren't necessarily enforceable. You need to go ahead and get temporary orders established if you're looking for something that can be enforced. And not doing the proper follow-up after you get that final decree, that's huge. Once you get the final decree, you need to make sure you tie up those loose ends, get the quadro done, which is the retirement paperwork, transfer property, get the income withholding for child support and everything else, change your name, all the other stuff to make sure that you're in a good position to move forward with the rest of your life. Critical deadlines is 20 days to answer that Monday after the 20 days. 60 days is the earliest it can be granted. And the temporary orders, it just varies based on circumstances and how quickly you or your lawyer move. Keys to success in this is understanding the vocabulary. Ask for everything you want up front. If you don't ask for it, you're not going to get it. Now, you can always change your mind later, but go ahead and ask for that so you preserve your right to get it, like alimony, the house, things like that. And that gives you have some wiggle room to negotiate during mediation. But like I said, if you don't ask for it up front, you might not be able to get it later. Respect the standing orders, respect the temporary orders. Focus on clear, workable parenting plans. Document absolutely everything and have realistic expectations. Understand that the court is looking at the child's best interest and not punishing your ex, and have realistic expectations in terms of timelines and finances and other factors that come into play. Preparation and not emotion is what will help you succeed in your Texas family law case.